Thank you very much, Petra. And again, thank you to the organizers and my fellow colleagues and speakers for making this such a great event. So I've got some slides. I'd like to preface this by saying that I'm probably the odd one out here. First of all, I'm the only, I think, non-professor and non-academic. I'm the practitioner. And I'm also the only one that's qualified in a non-signatory CISG country who's been invited to speak about the CISG and its interpretation. So I'll probably take a slightly different approach to my colleagues. I'm not really going to give you any answers. First of all, because Stefan said, whatever you do, don't give them any answers. And second of all, because I'm not being paid. So all I'm going to do is raise some questions, which I hope will maybe elucidate some of the issues for you mootees. So as an English lawyer, I suppose what I'll do is do the thing that everyone hates us for, which is I'm going to talk a little bit about English law. And I'm going to say, well, this position, when I had a look at it, there isn't that much case law to clarify with any certainty one position or another. And of course, the fact that the organizers of the Viz Moot decided to add it as an issue should have already indicated to you that that's the case. And that's the same position in English law. We have Section 12 of the Sale of Goods Act, and it's generally a two-prong right. First of all, it attaches a condition that the seller has the right to sell the goods, and secondly, it's a warranty for the quiet enjoyment of the goods by the buyer. And we only really have two major cases about it, one dating back from 1921 and a second from 1975, both by Lord Denning, which recognized the fact that intellectual property rights affecting the non-conformity would also fall within that position. So if we move on to the next slide. So here is Article 42.1, and as you can see, I've underlined some bits, and it's really those bits that you're all going to be tackling to try and decide whether or not it applies to the problem that you're dealing with. But whether or not it's the problem of the Viz or any other problem, these are the points that really you need to decide one way or another. And you'll see that it's quite chunky. There's quite a lot underlined there. I'm not a big fan of underlying, but in this particular case, I'll make an exception. So there's quite a few elements that we need to look at to be able to determine what the specific facts of the case that we're dealing with, which side they will fall, whether or not Article 42 applies, and if so, how. So if we can move on to the next slide, let's take the first element, which is right or claim. Well, you need to decide what is a right or claim. Does it need to be invoked? If you just have a mere right, but you never invoke it, does that trigger Article 42 or not? Well, most legal rights are normally come into effect on the invocation of such a right. So otherwise, the warranty is kind of pointless. Also look at Article 41. And Article 41, 42, and 43, they interplay together. So make sure you have a look at all three of them and then just go to 42. Valid rights or very valid claims, or any claim. What is a valid claim exactly? You need to think about that and think whether or not even an invalid claim would trigger it or not. And how would you know whether a claim is valid or isn't at any point? Bearing in mind that the language of Article 42 is prescriptive about time. It's at the time the contract was concluded. So whatever happens afterwards may well be irrelevant, and you need to be thinking about that. And you also need to be thinking about the general premise upon which Article 42 came about. So it's to protect the buyer. That's the underlying philosophy behind it. Is the buyer entitled to know of defects in title? Unlike Article 35, which all falls under Part 2 of the CISG as non-conformity, as Claudio has talked about now, what is a good? One deals with sort of tangible qualities of non-conformity, and Articles 41, 42, and 43 deal with title. So if we go back to Section 12, it's whether or not the seller has a right to sell whatever it is that they've sold to you. That's what Articles 41, 42, and 43 deal with. Everything else is dealt with under the earlier articles. So if you had knowledge of any defect on title, would that have affected the price? Well, you need to be thinking about that. The other thing you need to think about is our common law concept of caveat emptor, and this is perhaps a tension between civil and common law jurisdictions. Of course, anyone will know that in a common law jurisdiction like England and Wales, we tend to say, unless it's prohibited, you can do whatever you want. Whilst in a more prescriptive civil law jurisdiction, you have more positive rights. So they'll try and make sure that the parties have equal footing and all those lovely huggy, nicey things that we don't really have. You know, the good faith concept for an English lawyer is like a unicorn, isn't it? It's this thing that everyone is looking for that I'm not sure I'm convinced happens in reality, where the parties on opposite sides of the contract are truly going to act in good faith. But, you know, civil lawyers, our civil friends, certainly hold that in high regard. And so you need to consider that. And then finally, it's about quiet possession. It's like that second element of the SGA, the Sale of Goods Act, Section 12. Ultimately, if you're buying something, the purpose of this is to allow the buyer to enjoy quiet possession of what it is that they've bought. So if we can move on to the next slide. The next issue is the question that you have to think about. What about vexatious claim? Is anyone who makes an allegation, does that therefore give the buyer a right to some kind of remedy from the seller? You need to think about that, and again go back to that point about, well, how do you know whether a claim is vexatious or not? The language of Article 42 is somewhat vague on all that, and you need to decide, depending on whose side you're in, whether you wish to argue a more cautious approach or whether you need to argue a more bold approach. Okay, next slide, please. So the next point of the language of Article 42 is industrial or other intellectual property. That's not defined within the CISG itself, but you don't need to look very far to be able to find a definition that I suspect none of the arbitrators, not even Stefan, will be able to shut you down on, which is that the WIPO definition, the World Intellectual Property Organization, which says that it includes all rights resulting from intellectual activity in the industrial, scientific, literary, or artistic fields. So no need to say any more about that. The next slide, please. So then what we see that Article 42 really is a limitation. So if you read Article 41, you'll see that it's got a quite wide scope warranty for the buyer against the seller. What Article 42 does, and it's cited within Article 41, Article 41, it says, yes, you can have recourse, you can have a warranty for any non-conformity issues, hang on, except industrial and intellectual property rights, which will be governed under Article 42. And then what you see are limitations within Article 42. The first one is about knowledge. So, of course, the language of Article 42 itself is that at the time of the conclusion, the seller knew, and the seller knew is pretty straightforward. We know what knowing or not knowing is. It's actual knowledge. So if you can prove the seller had actual knowledge, that's not a problem at all. The next language is something which I do not like at all, but having looked into it, I suppose it does what it says in the tin, which is could not have been unaware. Apart from the fact that as a matter of English grammar, a double negative is a terrible, terrible faux pas. What does that mean? Could not have been unaware. Does it mean should have known? We know that actual knowledge is new, so it can't be that. It's got to be something beyond that. Does it raise a duty to make reasonable inquiries? Well, let's look at the language of Article 43, which says something slightly different. This Article 43 is to do with notices, and it uses, under the first subparagraph, reasonable time after he has become aware or ought to have become aware. Well, ought to have become aware, to me, is different to could not have been unaware. It imposes something more. And what that more is something that you have to figure out. But as an English lawyer, I suppose it means something more akin to constructive knowledge. You really should have known. It means something more like you could have inquired and you could have found out, and you had a duty to make those reasonable inquiries. And then knowledge of what? If you look again at the language of Article 42, there are two things. One is the use for resale, right? And the second is in respect of otherwise used. Well, what does otherwise used mean? And how much knowledge would you have known about that otherwise use? You need to think about those things. Because obviously, when we couple that together with the consideration of at the time of the conclusion of the contract, you would only know whatever you knew at that time and nothing else. And of course, then put that within the context of the timing. But to me, could not have been unaware. Well, they say a picture says 1,000 words. So if we can have the next slide, then this is my conclusion of could not have been unaware. Probably the ostrich test, have you buried your head in the sand or not? So moving on to the next slide, please. So the second limitation that appears to be imposed by Article 42, and that falls within Article 42(1) under the letters A and B. So first of all, it's to do with location. The first one is a state contemplated by the parties. Well, the first question to me as a lawyer is, what does contemplated mean? Does it mean it's in the contract or something outside of the contract? Was it just something considered by the parties? And to what extent has that been communicated between the parties? So that's the first question you need to think about. Then what if there was more than one state? Because the language of Article 42 is in the singular, just says state. So if there was more than one state, does it mean that you can only have the state, the first state you raised, or the main state? Or does it fall back into 41(2)(b, the default position? Well, consider that, and no doubt you can bring arguments either side of that. And then consider, what could the seller have known or could have not been unaware of that the buyer would not? And again, when you look at 42(2), this will all crystallize as to what are we trying to get to here. And then finally, there is generally going to be a presumption probably that the buyer will normally know or be presumed to know about any external factors in a place where the seller is going to resell or use, which is neither the seller's or the buyer's jurisdiction. And then look at the default position, which is under 42(1)(a), and that is basically that if 42(1)(b) is the default position, if 42(1)(a) doesn't apply, then 42(1)(b) will apply, and that just basically means the buyer's place of business. But that's all again caveated under 42(2). So if we can have the next slide. The second limitation is really summed up in this slide, I think. Did the buyer say where? And if they did, then you need to consider that state. And if they didn't, then it's probably the buyer's place of business. So next slide, please. So Article 42(2), again, the highlighted bits are the bits that matter. So obligation of the seller, and this is an exemption to the obligations of the seller. And this is where either the buyer knew at the time or they provided some goods. So if we can go on to the next slide. In a nutshell, what the third limitation is about is, did the buyer know what the seller knew? Because if they did, then that's an express exemption to that warranty and that liability. Secondly, did the right or claim, is it in relation to something that the buyer was responsible for? And look at this case of the Israeli shoes. It'll give you an idea. So in other words, if the buyer is whatever they provided to the seller to make something or to provide something which was a final good that was sold to the buyer, if the infringement relates to that aspect of the contract, then it surely would not be fair for the seller to be responsible. And again, it's a third limitation to the seller's warranty. So the next slide, please. Again, a visual interpretation of the third limitation is, can the seller point to the buyer for the fault? And if they can, then they're probably going to be okay. So the next slide, please. So finally, just general considerations. One is the burden of proof. Well, whose burden of proof do you think it might be? And the standard of proof. Again, these are probably considerations that I, as an English lawyer, am more concerned about than potentially civil lawyers, certainly on the standard of proof. And the burden of proof can be a little bit more movable than perhaps we would have in English law, where he who asserts must prove. The second point you need to consider is the interpretation of Articles 41, 42, and 43 will be subject to the earlier articles and the earlier impositions. So things like the duty of good faith in international contracts imposed by Article 7. Secondly, the point about no parole evidence rule. You can go beyond the words of the contract. You can go and look at other communications. So, you know, one general piece of advice, which I hope Stefan will not scold me for, is read every page of the bundle, because there might be some nuggets in there, and no doubt there will be. So you can use all that stuff under the CISG, which of course you wouldn't be able to under English law. And finally, no written requirement. So is there anything in the witness statements which might not be within a document itself, but any oral evidence which is contested? And then look at what the remedies are that are available. Are they adequate? Because in certain circumstances, of course, these things, Article 42, it's predominantly, I get the impression, it was foreseen that it was to argue potentially registered IP rights or industrial rights. But there's a whole host of non-registrable or non-registered IP rights, which may throw a different light on the situation, and especially in respect of the available knowledge and available information in the public sphere, and of course, who has the power balance in terms of information. And then just have a quick look at the CD Media case, which is one of the leading authorities on Article 42. Okay, next slide. So there we are. That's the end. I've been short and sweet, and hopefully fast, Ferrari fast. And that leaves a little bit of time for all your questions. Thank you very much again.